located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
let us try to analyze ano ang ibig sabihin ng progressive scheme of taxation sa Constitution. Ano ang ibig sabihin nito? Okay, ang ibig lang sabihin nito is whenever the Congress is enacting a tax law, all right, they should try their best to address their intention to the ability to pay principle of the people. Okay? So they should come up with many rates from the lowest to the highest. So that is what we call progressive scheme of taxation. So you will see na ang ating income tax tumutugma sa progressive scheme of taxation because sa tax code, ang income tax rate ng individual taxpayer
action by which a party sues another for enforcement or protection of a right or prevention or redress of a wrong. So what are the keywords here? Enforcement, protection of right, prevention or redress of wrong. Tandaan nyo, enforce, protect, right, prevent, redress, wrong. Okay. Remedy by which a party seeks to establish three things: status, right, particular fact. Okay. Ano yung sa television, yung commercial? SRP. Ano yung SRP? Suggested retail price. So tandaan nyo, to establish
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial agreements.
What is our definition of the practice of law? We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making venture. And law advocacy is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers, and gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is
In Spouses Minjola versus Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between 2 persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are 2 aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act a violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
there are two kinds of injunction: preliminary mandatory injunction, preliminary prohibitory injunction. Now, lifetime of a TRO issued by the RTC, by the Court of Appeals, and by the Supreme Court. So, if it is issued by the RTC, you have 20 days. Within the 20-day period, then there shall be a hearing. The hearing is mandatory as regards to the application for preliminary injunction, either mandatory or prohibitory. Now, after the lapse of the 20-day period and there is no injunction issued, it becomes facto officio. Now, as far as Court of Appeals is concerned, the lifetime is 60 days. Now,
what is involved is what appears to be a discriminatory act on the part of government or agents of the government. The proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory act.
First, let us speak of the principles of generality and territoriality. Remember that questions about these two principles were asked in the 2015, 2017, 2018, and 2019 bar examinations. Okay? So far as generality is concerned, consider the persons which are exempt from the general application of Philippine criminal law by virtue of the principles of public international law, and the person exempt from criminal from the application of Philippine criminal law are the sovereigns, chief of states. We have ambassadors, ministers plenipotentiary.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like, for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or, for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand, and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
In the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between 2 persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are 2 aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act a violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
Let us try to analyze ano ang ibig sabihin ng progressive scheme of taxation sa Constitution. Ano ang ibig sabihin nito? Okay, ang ibig lang sabihin nito is whenever the Congress is enacting a tax law, all right, they should try their best to address their intention to the ability to pay principle of the people. Okay? So they should come up with many rates from the lowest to the highest. So that is what we call progressive scheme of taxation. So you will see na ang ating income tax tumutugma sa progressive scheme of taxation because sa tax code, ang income tax rate ng individual taxpayer
Action by which a party sues another for enforcement or protection of a right or prevention or redress of a wrong. So what are the keywords here? Enforcement, protection of right, prevention, or redress of wrong. Tandaan nyo, enforce, protect, right, prevent, redress, wrong. Okay. Remedy by which a party seeks to establish three things: status, right, particular fact. Okay. Ano yung sa television, yung commercial? SRP. Ano yung SRP? Suggested retail price. So tandaan nyo, to establish
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
Good day to our dear attendees from different parts of the country. I pray that you're all in a great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual class and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer for today is a law professor, bar reviewer, MCLE lecturer, legal consultant, radio host, and a stand-up comedian. He obtained his bachelor's degree, cum laude, from the University of the Philippines Diliman campus. He then finished his Juris Doctor, as a scholar, at Ateneo School of Law. From 2003 until now, he is a law professor at De La Salle College of Law, PCU Institute of Law, San Sebastian College of Law, and the University of Manila College of Law. In 2013 until 2015, he served as chairperson of the Commercial Law Department of De La Salle University. He was a former consultant to the Office of the House Speaker from 2016 until 2018. Likewise, he served as Chief Legislative Officer in the Office of Senator Miriam Defensor Santiago from 2001 until 2006. Currently, he is a consultant to Commission on Human Rights, Office of Congressman Bobby Pacquiao, and Office of the Vice Mayor of San Juan. He is a partner in Esquerra, the Asus D and Chico Law Offices. He is the radio host of Thangal Karapatan, aired over Radio Veritas every Saturday. He is a stand-up comedian at Insanathank and Comedy Cartel. Ladies and gentlemen, please welcome Professor Edward P. Chico.
Magandang araw po sa inyong lahat. I am Attorney Edward P. Chico and welcome to this web free online series which is brought to you by the Virtual Companion of the Villasis Law Center. So as you prepare for your bar examination, you can perhaps include this as one of your source material. So this is not really a formal review at Villasis Law Center. But of course, in this exercise, in this webinar, we want you to optimize learning, and you can do that by sharing this with your friends. So what you can do right now is like the VLC Facebook page and share this FB live session. Tapos nauuso na rin po, di po ba yung mga watch party which you can actually do, and you can outright tag your friends so they can take part and participate in this webinar. Kagaya po ng sinabi ko, this is not a formal review proper. So medyo discussion lang tayo, huntahan, kwentuhan, usapan lang in the hope that as we go on, may mga bagong perspectives at may mga bagong kaalaman tayong mapupulot. But before we start, please comment VLC if you can hear me clearly. Kasi ang hirap naman po, if you can hear me clearly. Kasi ang hirap naman po, di ba, yung salita ka ng salita, nagpapahayag ka na nagpapahayag, tapos sa bandang huli, wala naman palang nakakapakinig sa'yo. But of course, hindi kayo yun. I'm pretty sure the fact that you like this page and that you are viewing this webinar right now presupposes that you want to be part of this exercise. So I feel honored. Ang pag-uusapan po talaga natin ngayon ay family code. Particularly, we will focus on rights of children, the civil status of children, among others. But the intention here essentially is for us to be able to come up with a bird's eye view of the family code. Ano ba yung mga principles? Ano ba yung mga madalas pag-usapan? Para pagka binasa nyo mismo yung family code at mga pertinent cases decided with the Supreme Court, mas madali nyong mauunawaan. Diba? So, ang iniisip po dito sa ating webinar, pinag-uusapan nga namin ni Atty. Villasis, sabi niya sa akin, Ed, ba't hindi natin gawing usapang asawa o usapang misis? Diba? Napakaganda po ng pag-uusapan natin sa webinar na ito. It's all about the family code. Pero as I said, this is not a formal review proper. So usapan lang, muntahan lang, discussion lang. Because there are certain issues which I believe are not actually very, very clear to you. So through this webinar, we hope to be able to clarify or illumine these certain issues that are somehow not very, very clear to us. Para pag nag-review na tayo sa family code, binasa natin yung law, yung jurisprudence, it's a lot easier for us. Actually, pinagtatalunan nga namin ni Attorney Kit, ano ba magandang title natin dito sa webinar nito? Sabi niya sa akin, siguro maganda, Attorney, tawagin na lang natin usapang misis. Alam niyo naman si Attorney Villasis, takot na takot yan sa misis niya dahil sapagkat mahal na mahal niya. And ako din naman, I really love this topic because it's all about love. You know, even despite the fact that I'm a lawyer, I do litigate, I appear in court every day, I have to be honest with you, I hate confrontations. Because sa bandang huli, I'm more of a lover than a fighter. So kaya tuwang-tuwa ako sa topic na binigay sa akin ni Atty. Villasis, family code. Sabi niya, pag-usapan natin ang pag-aasawa. Sabi ko nga, sa lahat ng usapin ng batas, pag-ibig pa rin ang talagang laging interesado tayo. In fact, if you check out SOCMED, you will realize that a lot of the questions pertain to nullity and annulment cases. May nabasa nga ako, medyo nag-viral, di ba sabi niya, attorney, after 5 years, pwede na bang magpa-annul yung mag-asawa? Pero yung spelling niya, A-N-A-L. So pag binasa mo parang attorney, after 5 years, pwede na bang magpa-anal? Hindi ba? So ang sagot ko lang dyan, kausapin natin si Atty. Villasis. Kasi marami na siyang nahawakan na mga kasong ganyan, di ba? Of course, may mga sagot pa, sabi, pwede naman pag mahal mo, pwede kang magpa-anal, pero ako, may mga kakilala nga ako kahit hindi nila mahal. Okay na okay sa kanila yan. But of course, I'm just joking about it. But the reality is that a lot of people are pretty much interested with marriage and all issues are relative to the same. So ngayon, yan ang pag-uusapan natin. It's all about love, and as I always say, aanin mo kung may PhilHealth ka nga, pero kung wala ka namang pag-ibig. So right off the bat, ang unang pag-uusapan po natin yung marriage. Kasi everything emanates from the code.
Villasis law.
You may not believe it, but Article 1 is very, very crucial. So if I were you, if you were reviewing for the bar, what you can do is memorize Article 1. Because if you can memorize Article 1, it's a lot easier for you to answer query relating to the family code. Ano ba yung sinasabi ng Article 1, hindi ba? Look at the definition of marriage. Nakakatuwa. Ang sabi doon, marriage is a special contract of permanent union between a man and a woman. Now, take note of the word permanent. Diba? For the purpose of establishing conjugal and dwelling life. And according to Article 1, it is an inviolable social institution. It's the foundation of the family whose nature, consequences, incidents are governed by law and not subject to stipulation, but of course parties may freely fix their property relations, but still subject to the limits imposed by the code. So if you look at the definition, there are some crucial phrases or words there that we should be mindful of. Una nga, yung word na permanent. Yung phrase na inviolable social institution. Importante yon, hindi ba? So pinapakita dito na napaka-importante o napakahalaga ng institusyon ng pag-aasawa. And in fact, Article 1 is taken from Section 2, Article 15 of the Constitution, which highlights marriage as an inviolable social institution. Kaya nga sabi ng Supreme Court in a long line of cases, marriage is at least a civil contract but not at most a civil contract. Anong ibig sabihin nun, attorney, di ba? Marriage is not at most a civil contract but at least a civil contract. Sinabi ng Korte Suprema yan because marriage is a different animal in itself. It is the only contract that cannot be subject to stipulation. Di ba? Sabi dun sa Article 1, the nature, incidents, repercussions, di ba, are governed by law and cannot be stipulated upon by the parties. And with regard, of course, to property relations, you can fix that. Pero look at Article 1, it also tells us it's still subject to the limits imposed by the code. So anong ibig sabihin noon, di ba? Marriage is at least a civil contract but not at most a civil contract. Yun ang ibig sabihin noon. Ito lang ang kontrata na hindi ka pwedeng mag-stipulate. You can just consent to it, but all other terms and conditions are not subject to meeting of minds, so to speak, because everything is provided for by the law. Now, the question is, why? Bakit ito lang pag-aasawa ang tanging kontrata na hindi kayo pwede magdikta ng inyong particular na terms and conditions? Alam niyo kung bakit? Because according to the Supreme Court, marriage is vested with public interest. And why is it vested with public interest? Because according to the Constitution, as I said earlier, it is an inviolable social institution and therefore, the state would want to protect it. And that definition is actually very, very telling because all other provisions in the family code would relate to that. And I'll give some, I'll specify some. So for example, pag nag-file ka ng annulment or nullity case sa korte, di ba? So essentially, itong petition mo is civil in nature, but this is the only civil case where the fiscal intervenes. Normally kasi, di ba, if you file a civil case, it's just between the parties and the parties at liberty to essentially hire their respective lawyers, and these lawyers will appear in court. And when it's a criminal case, you ask the fiscal to prosecute the case. Why? Because when you commit a crime, you are committing a crime against the state. So in effect, the fiscal is the representative of the state. So sa criminal case lang nangyayari yan. Pero sa annulment and nullity cases, sa mga hindi pa abogado sa inyo, pag nagsampa kayo niyan, nakikialam ang fiscal. Anong pakialam ng fiscal? To begin with, the fiscal has to see to it that there is no collusion between the parties and that pieces of evidence are not fabricated. Why would the fiscal do that? Kasi may interest ang Estado dito. Gustong tiyakin ng Estado na kapag nag-file ka ng annulment, yaan ay makatwiran at naaayon sa batas. So, di ba? Nakita nyo na ang kagandahan ng marriage being vested with public interest. Pangalawa, because marriage is vested with public interest, do you ever realize that when you file a petition for legal separation, there's a cooling off period of 6 months? Ano ibig sabihin ng cooling off period na yan? The court will not actually conduct hearing. Bibigyan kayo ng pagkakataon para makapag-isip-isip. Bakit? Because at the end of the day, the purpose of the state is to preserve the sanctity of marriage as an inviolable social institution. Parang sinasabi nila, Baka hindi lang kayo nagkaintindihan, may hindi kayo pagkakaunawaan, madakdak si misis, lasinggero si mister. Baka pwede kayong umupo at mag-usap and you can patch things up. So nakita nyo yan, ano? Isang repercussion yan. Ano pa? Even if you file a case for nullity or annulment, the ground should exist at the time the marriage is actually celebrated. So anong ibig sabihin yan? Kung gusto mo makipaghiwalay, dapat yung ground mo from the time na ikaw ay nag-asawa. So dapat mapakita mo sa korte na may depekto na bago pa man kayo nag-asawa. Kasi kung walang depekto, something goes wrong along the way, you can no longer sever ties as husband and wife. Because the presumption, as I said, is always to preserve marriage. So kung makikita mo, lahat ng mga provisions sa family code may kaugnayan doon sa principle that marriage is vested with public interest. Di ba kahit sa prenup agreement, in the prenup
Villasis
agreement, di ba you can fix your property relations but you are still limited by certain provisions of the family code. For example, in your prenup agreement, di ba hindi pwedeng you would start with absolute community and after 10 years, you will convert into absolute partnership of gain. Hindi pwede yan because the family code is clear na kung ano ang property relations mo at the time the marriage is celebrated, you go on, except in cases of complete separation of properties, which can be done judicially, particularly in cases about legal separation. So, napakaraming batas patungkol lagi dito. So, huwag niyong kalilimutan lahat yan. And now, let us discuss the requisites of a valid marriage. Of course, there are essential requisites and formal requisites. Kung titignan mo yung mga requisites na to, isa lang ang tatandaan natin. If one is absent, the marriage is automatically void. Walang bisa. Hindi ba? So what are the essential requisites anyway? So essential requisites, we're dealing with, number one, legal capacity between a man and a woman. Now, if you talk about legal capacity, according to the family code, hindi ba, there is legal capacity. Number one is if you are of age, so meaning at least you are 18 years old. Number two, of course, it should be between a man and a woman. So which explains between a man and a woman. So which explains why same-sex marriage, at least in our jurisdiction, is not yet allowed. Kasi it's pretty clear that when you talk about legal capacity, it should be between a man and a woman. Pero ang tanong, paano kung transsexual ka or nagpa-sex change operation ka at naging babae ka na? Will you be considered a woman for all intents and purposes? Sadly, wala pa talaga tayong kaso sa Supreme Court that basically settles that issue. But in the US, kapag chinek mo yung AMJUR, or pwede nyo i-google, basahin nyo yung mga decisions sa Korte Suprema, before same-sex marriage was allowed in some states, there was really a divergence of opinions. May mga kaso na nagsasabi, pwedeng sabihin, babae na siya kasi sa puso niya, babae siya. These are liberal constructions. But the general weight of authority in the US is to the effect that you should be born a woman to be considered a woman. And the reason, according, at least in those decisions in the US, is easy to see. Kasi ang purpose daw talaga ng pag-aasawa ay pagkakaroon ng pamilya. And if you talk about having a family, you're talking about procreation. And procreation is utterly impossible between people sharing the same sex. So kaya sa America, before same-sex marriage is allowed, hindi siya very, very clear. Pero in our jurisdiction, clearly, it would not be allowed. And yun nga lang, yun sa trans siguro, dapat magsapan ng kaso sa Korte Suprema. Pero sa tingin ninyo, is it high time the court should consider a trans person, a woman, despite the fact, for example, that he is born as a man? And besides, kasi may SOGI bill tayo ngayon, ano? Kasi ang perspective now is that being gay, for example, or being lesbian, or being trans, is actually more of a gender identity and expression. So, hindi daw siya lifestyle, hindi siya choice. So, if that bill will be enacted into law, then that would actually a plus community. But anyway, I'm digressing now. Pero nabanggit ko lang, ano, when you talk about legal capacity, it should always be between a man and a woman. And number 3 requirement of legal capacity is that there should not be impediment under Articles 37 and 38. These are marriages that are considered void by reason of public policy, halimbawa between the adopter and the adopted, and between the mother-in-law and the son-in-law, and the list goes on. So if you suffer from impediment based on 37 and 38, then there is no legal capacity. The second requirement, of course, is consent. Consent that should be freely given by the parties. Now, if the consent is vitiated, it's as if there is no consent at all, which is why you can file a petition. Natin yung annulment, the marriage is valid until annulled. I won't discuss this anymore. Alam nyo na yan kung law students kayo. But the point is, consent should actually be whole. It should actually be given. Now, let us requisites. Number 1 is the authority of the solemnizing officer. Meron siyang issue dyan ng good faith, bad faith. Hindi ba? Meron tinatawag sila doon na parang question of law, question of fact. Depende kung ang binasa mo, yung opinion ni Tolentino o yung opinion ni Justice Kagiwa. Ultimately, hindi to settled case talaga. So kung merong bar question relative to that matter, you can actually cite both. And of course, a valid marriage license and a valid marriage ceremony where parties appear before the solemnizing officer and they would declare each other as husband and wife. Now, interestingly, pag tingnan mo yung Article 36, it's really a different species in itself. You know why? 36 or psychological incapacity. It is the only ground for declaring a marriage void despite the fact that both the essential and formal requisites are present. Hindi nyo ba naisip yon? May legal capacity kayo, may consent freely given kayo, may authority yung solemnizing officer, may valid marriage license, di ba? Meron kayong marriage celebration, merong marriage ceremony, and yet, the marriage is still void because of psychological incapacity. So, kaya pag tinanong ka sa bar, ano ba yung exception, di ba, to the rule that all the essential and formal requisites are present, and yet, the marriage will be deemed void. Ang exception yan, yung psychological incapacity. And interestingly, there's a long line of cases. There's a plethora of cases about psychological incapacity and they have yet to actually discuss that. Minsan nakakalito rin di ba? Mamaya pag-usapan natin yung psychological incapacity para hindi tayo malito. Incidentally, before we proceed further, gusto ko lang sana pag-usapan yung, it's a 2017 case, which is something we can talk about because it relates to marriage being vested with public interest. The case is Tilar versus Tilar. Ang maganda kasi sa kaso na ito, yung husband filed a petition for nullity based on psychological incapacity. Ang ginawa ng regional trial court, it refused to take cognizance of the action because according to the court, the trial court, it involved a church wedding. And because there is supposedly a separation between the church and the state, the trial court said it has no jurisdiction over it. And that is actually pretty interesting. Now, the court in resolving this case, by the way, this is a 2017 case, so this is fairly new. Sabi ng Supreme Court in resolving the case, although it involves a church wedding, and therefore should be within the rules and regulations of the church to which the parties belong. At the end of the day, any marriage, whether civilly or through some church ceremony, are always, would always involve civil issues governed by the family code. So, which is why according to the Supreme Court, since marriage is vested with public interest, therefore, regional trial courts cannot refuse to take cognizance of a case just because it involves a church wedding. And besides, what the court is simply doing is resolving the civil aspect of the marriage as governed by the family code. But as regards the church wedding itself, the decision of the court does not ipso facto sever ties of the husband and wife based on the tenets of the church, which of course supervises the wedding. So sana malinaw yun. Nabanggit ko lang, naalala ko lang because it's a fairly recent case. Ang magandang pag-usapan ngayon, yung usapin ng divorce, Because remember Republic versus Manalo. Republic versus Manalo essentially tells us that a Filipino who is married to a foreigner can actually procure divorce and have that divorce recognized here. Marami ang nagsasabi, di ba, Republic versus Manalo is actually a case of judicial legislation because Article 26 of the Family Code is very clear. Di ba, ang nakalagay doon, it should be the foreign spouse who should obtain divorce, and if he is allowed to remarry, therefore, the Filipino by reason of equity is also allowed to remarry. And subsequently, nag-evolve po yan. May mga desisyon ng Korte Suprema to the effect that if you are a naturalized citizen of another country and a former Filipino, you would be considered a foreign spouse for all intents and purposes. But all of these have already been rendered moot and academic because of Republic versus Manalo. Ang sinasabi dito, even if the Filipino spouse would obtain divorce abroad, then ipso facto, that divorce can actually be recognized here. Because in this case, diba, she was married to a Japanese. She was the one who procured divorce in Japan, and she went back here. She went to Dagupan and institute the necessary petition for recognition of the divorce decree. And that has become an issue kasi Pilipino ka. But right now, that is already settled. But the good thing about the Supreme Court is in recognizing the very spirit of Article 26. You have to understand that under the Family Code, divorce should not be allowed. Because again, you have to look at the definition of marriage in Article 1 for you to be able to understand why. So, hindi talaga okay ang divorce. The only reason why Article 26 is provided in the Family Code is for purposes of equity. Kasi nga, di ba, if the foreign spouse would procure divorce and he will be allowed to remarry, it would be unfair if the Filipino spouse would not be allowed to remarry as well. So, if Article 26 is incorporated in the Family Code by reason of equity, it also follows, therefore, that allowing a Filipino to procure divorce abroad and allow him, of course, to file the necessary petition for recognition of divorce decree, it makes reason, therefore, that by reason of the same equity, he should be given that opportunity. Actually, nalito ako sa sinabi ko. Ganun na pag tumatanda, hindi ko, ang dami kong clauses na sinabi, nakalimutan ko na kung saan ako naminto. Pero naintindihan niyo yung sinasabi ko, I'm pretty sure it's very clear naman. So, in other words, the case of the Republic versus Manalo is also a case of equity in the same manner that Article 26 of the Family Code is also a case of equity. But please, do not be misled to believing that any Filipino who goes abroad and procures divorce can have it recognized here. So kung halimbawa kasama niya, Filipino pa rin, so hindi siya pwedeng mag-procure ng divorce. She would still be governed by Article 16, di ba? It follows you wherever you go. So halimbawa, paano kung dual citizens kayo pareho? Pareho kayong Filipino but at the same time, naturalized citizens din kayo ng ibang bansa. O kaya, yung kaso mo kagaya ni Gabi Lopez. Hindi ba? At birth, dual citizen ka at birth. Pinanganak ka sa Amerika as a US citizen, pero como ang magulang mo ay Filipino, by blood, Filipino ka rin. So what if that is the case? Pareho silang dual citizens, nag-procure sila ng divorce, can that be recognized here? The answer is still no. Because for all intents and purposes, if you look at the dual citizenship law, the understanding is that they still knows. It would have been different kung hindi ka dual citizen, naturalized citizen ka lang ng bansa na yon. And the other interesting aspect about this divorce decree, or at least filing a petition for recognition of the same, is concerned, ang maganda rito, the Filipino spouse who resides abroad can actually file a petition even if she doesn't reside here. With the understanding, of course, that when the time comes that she's supposed to testify, he should come here and attend the hearing. Pero kahit nasaan siya, pwede siyang mag-file. And even the foreign spouse can actually file the necessary petition for said recognition. So, hindi kinakailangan yung babae lang yung magpa-file. And interestingly, sabi din ng Korte Suprema, just because there is a divorce decree granted in another country does not necessarily mean that the court cannot entertain issues relative to custody, support, or division of properties or liquidations of assets and properties. So in other words, kung may divorce decree ron, tapos may issue ng custody, may issue ng division of properties, may issue ng support, 'di ba? The trial court can recognize the divorce decree, but it does not prevent the trial court from deliberating further on those other issues. So yan, malinaw na malinaw po na sinasabi po
Villasis
yan
Law Center.
ng Korte Suprema. Ngayon po, magandang pag-usapan po natin, inom lang po tayo ng tubig. Kanina kinata ko, sabi ko naman ng tubig. Sabi nila pagka daw inom ng tubig, pwedeng i-cut muna. Pero naisip ko, gusto kong makita nyo kung paano ako inom ng tubig. Di ba? Pag inom ng tubig, parang sayang-saya ako eh. Ayan, nawala ako nang pinag-uusapan natin. Divorce, di ba? So, eto, tatandaan natin, again, divorce at the end of the day ultimately is an issue on equity more than anything else. But there's this interesting case, naisip ko lang, yung case of Co versus Republic. Kasi ang tanong dito, di ba pinag-usapan natin, marriage is vested with public interest. Paano kung ikaw ay nakikipaghiwalay at masama ang intention mo kung bakit ka nakikipaghiwalay? Can that be a factor in denying your petition either for nullity or annulment? Because in the case of Co, ganun yung istorya. Yung lalaki, he filed a petition for nullity on the basis of the absence of a marriage license. In the course of the hearing, that the reason why he was asking for nullity is because he was having an illicit affair with another woman. To extricate himself from marriage so that subsequently he can, formalize his relationship with this person. Ang maganda dito, yung Court of Appeals, didesisyonan yung kaso, kinonsider yon as a factor. Diba? But before we go into that, ano ba yung kaso talaga? Ang kaso lang talaga nila dito, yung usapin ng marriage license. Because it turns out that the husband was able to get a certification from the local civil registrar to the effect that based on their records, such marriage license does not exist. And normally it would suffice because remember in the previous Nick Dow case, the Supreme Court said that such certification would be sufficient or adequate to prove that there is no marriage license. And if that is the case, the burden now would shift to the person who claims there is and would be required to present an authentic marriage license. So sa kaso nito, yun lang ang pinag-uusapan nila talaga. Walang marriage license, may certification na walang marriage license, dapat is-sever mo na yung tie nila as husband and wife. Pero sabi na siya, hindi ang motibo mo. Again, tandaan po natin, everything is governed by the family code and the intention and the motive is actually immaterial for as long as a ground for the same actually exists. Ngayon po, pag-usapan po natin yung talagang matagal na gusto ko talagang pag-usapan dito sa webinar na ito. Teka, nakalimutan ko, pag-usapan din pala muna natin yung issue ng psychological incapacity kasi maraming hindi nakakaintindi kung paano ba yan na-apply. And besides, those of you who are not lawyers or not even law students, who are not reviewing for the bar exams and you just want to be entertained and at the same time learn something from this webinar series, pag-usapan natin ano ba itong psychological incapacity. Ang kagandahan kasi sa psychological incapacity, this is actually, psychological incapacity, the guidelines for this are actually set by the case of Republic versus Molina. Mayroong listahan sila ron, 8 or 9. You can just check that out. Masyadong mahaba pag-usapan. But at the end of the day, ang sinasabi nila, di ba, psychological incapacity, number 1, should be characterized by gravity. So, ibig sabihin, yung psychological incapacity niya should be such of serious nature that it basically affects the harmonious relationship existing between the husband and the wife. Interestingly, sabi din sa kaso ng Republic versus Molina, all the grounds for legal separation can also be the same grounds that you may use to point out that the person is psychologically incapacitated. So, unang-una dito, kagaya na sinabi ko, it is characterized by gravity. Pangalawa, di ba, kinakailangan incurable. Ano ibig sabihin ng incurable? Hindi na siya talaga magagamot. Like the person is born with the psychological incapacity so that no amount of reform or rehabilitation or therapy could actually change his behavior. Psychological incapacity na siya talaga kahit kailan. At pangatlo, yung tinatawag natin na juridical antecedents. Ano yung importansya ng juridical antecedents? Because the court, the family code is certain in saying that they should exist at the time the marriage is actually celebrated. Kaya nga, kung halimbawa, mabait naman yung asawa mo at some point naging salbahe, legal separation ka lang. Hindi ka pwedeng mag-file ng petition for nullity based on psychological incapacity. Alam mo, sa practice ko bilang abogado, maraming petitions for psychological incapacity yung nadi-deny. Alam niyo kasi sila nagkakaproblema. Isang problema nila, yung establishment ng juridical antecedents. Kaya mahalaga, pag nag-file ka ng petition, importante na kasama sa narration of facts mo nung panahon na nagkakilala sila. Yung behavior pa lang nung panahon na nagkakilala sila. For you to be
Villasis
able to
Law Center.
establish that although the psychological incapacity is not yet clearly manifest, diba? At least at that time, you could already see that there is somehow this psychological incapacity on the part of the person. Kaya dyan, ikikwento mo na mag-boyfriend kayo, diba? Pag nagde-date kayo, ini-Indian ka niya kasi minsan piniprefer niya yung friends niya. Tapos minsan pag nagagalit siya, nagmumura siya. Tapos, kung magkaminsan, pag ayaw niya sa'yo, hindi ka niya sisiputin. Tapos, pag may obligasyon siya, hindi niya sinusunod. May pangako siya, hindi niya tinutupad. Although, paminsan-minsan lang. Tapos, nung nag-asawa na kami, ganun pa rin siya hanggang sa lumala. So, nung lumala, talagang hindi na umuwi ng bahay, hindi nagbibigay ng sweldo. Diba? Himbis na ibigay ang pera para sa suporta naming mag-anak o ng aming pamilya, binubuhos lang sa mga barkada sa kaiinom, 'di ba? Palamura, palaging galit, mayroong problema sa anger management. So, these things kapag i-present mo sa korte, you would now be able to establish this animal called juridical antecedents. 'Di ba? Kaya hindi pwede na kinasal kayo nitong panahon na ito, tapos napansin mo ang daming bagay na hindi niya ginagawa, and therefore that person is psychologically incapacitated. Hindi pa pwede yun. So, if you file a petition, dapat ikwento mo na mag-boyfriend pa lang para makita na yung traces of said psychological incapacity and therefore satisfying the element of juridical antecedents. Babalik din ako sa incurability, no? Nakakatawa yung issue na yon. Sabi ng Supreme Court, di ba, the psychological incapacity should be incurable. But interestingly, sabi rin ng Supreme Court, it only applies to that particular marriage. So, ibig sabihin, you might be psychologically incapacitated with respect to A, but with respect to B, it doesn't follow. Pero di ba, incurable nga? Baka incurable lang, pagdating sa asawa na yun, So, nakakatawa lang talaga isipin. Anyway, ang madalas na tinatanong nila, if you file a petition for nullity and it is declared by the court, di ba, ibig sabihin, the marriage becomes void ab initio. And the understanding is that if it's void ab initio, it presupposes therefore that it's as if there is no marriage at all. So kung wala naman parang kasal, why do you still need to go to court? Well, the answer can be found in Article 40 of the Family Code, because for purposes of the marriage, you need to obtain your judicial declaration of nullity. Because only the court can declare that the marriage is void. And unless you get that declaration from the court, there is no way you can get married again. And if you do that, it amounts to bigamy, for which you can be held liable criminally. Paano kung hindi ka nagpunta sa korte? Maari mo bang i-allege yung pagiging void ng marriage sa ibang proceeding? So in other words, can you attack it collaterally? The answer is yes. According to the Supreme Court, unless you fall under Article 40, which means your purpose is to remarry, you don't need to get the judicial declaration of nullity. You can always introduce it as part of your evidence in other proceedings whose main issue is different from declaring it as a nullity. So halimbawa, testate and intestate proceeding, usapin ng manahan. Feeling mo yung asawa talaga, hindi naman siya asawa because the marriage entered into is void ab initio. Well, you can always attack the same collaterally. You can always introduce evidence to show that indeed the marriage is void. For example, there is lack of marriage license or a valid marriage license. So sa usapin ng manahan na yun, pwede mo yung ipresenta as evidence to prove that the marriage is void, and on the basis of that, the court can appropriately determine who the lawful heirs are and the respective amount these lawful heirs would get. So yan ang purpose ng yan ang purpose ng pagiging void ng isang kasal. You can always attack it collaterally. Eh ang tanong, sir, paano yung mga voidable marriages? Diba? Pag voidable marriage, ibig sabihin, valid until annulled. Can you attack it collaterally? The answer is no. For two reasons. Because chances are, kapag nagkaroon na ng usapin, malamang most likely na ratify na yung annullable marriage or nag-prescribe na yung period within which to file the necessary petition to declare the marriage as voidable. Pangalawang rason, and this is always important, remember the definition of a voidable marriage is valid until annulled. So, ibig sabihin, if you fail to go to court, and because only the court has the liberty to declare it as voidable, it remains valid. So halimbawa si A and B, mag-asawa, voidable yung marriage nila. Namatay ngayon si B. Can you now introduce evidence to say that the marriage is voidable? The answer is no. Because by the time A dies, the presumption is that it is valid. And as I said, only the court can essentially declare it otherwise. So yan po yung distinction. Again, para wag tayong malito, if it's a void marriage, you can always attack it collaterally because it is in the nature of void marriage. It's as if there is no marriage at all. But if it's a voidable marriage, it will always be presumed valid unless you go to court. So that which is why you cannot introduce this as evidence, or which is why, in other words, you cannot attack. Na malinaw po sa atin yan para maintindahan natin talaga pag nag-aaral na tayo dito ng family code. Ngayon, merong isang issue na magandang pag-usapan. Merong 2006 case na I'm pretty sure hindi pa talaga na-overturn kasi tumitingin ako ng ibang mga kaso ng Korte Suprema, and it seems to me it's still the prevailing ruling. In that case kasi, that case is called Malion versus Alcantara. That case is pretty interesting kasi ang nangyari dito, si Malion, he filed a petition for nullity against his wife based on Article 36 or psychological incapacity. But that case, that petition was dismissed by the court at umabot ito sa kanyang apela na dismiss pa rin. So the next thing he did was to file another petition for nullity on lack of a valid marriage license. So ngayon, yung asawa niya nagreklamo. Sabi it amounts to res judicata and forum shopping because there was an earlier ruling dismissing the petition for nullity. So ang sabi ngayon ni Malion, that particular argument is not tenable because I have a different cause of action. The cause of action in the first case is psychological incapacity, which understandably was denied by the court. But the second cause of action now is absence of a valid marriage license. Eh di ba, when you talk about res judicata, when you talk about forum shopping, you're talking about identity of party, subject matter, and cause of action. Ito, hindi mo naman in-split yung cause of action. Magkaiba talaga. But interestingly, sabi ng Korte Suprema, if that is the case, for example, you earlier filed a petition for nullity that was dismissed, if you file another petition, even if the ground is different, it already amounts to res judicata, which means, of course, that the second petition will be dismissed or denied. Parang ang hirap tanggapin, Kasi di ba, honestly, iba naman yung cause of action eh. Yung cause of action mo this time, absence ng valid marriage license eh. Pero ito yung paliwanag ng Supreme Court in so supporting its argument. Sabi kasi ng Korte Suprema, if you file a petition for nullity, for example, you are expected to lay down all your arguments, to present all your pieces of evidence, and to cite all the possible grounds why you are pursuing that petition for nullity. You are not allowed to split your causes of action because in so doing, you are not only wasting resources, but you are also making it difficult but you're also making the court inconvenienced by such action. So kaya in this particular case, na-deny yung kanyang second petition, which can only mean one thing. Ibig sabihin, their marriage will remain valid forever. Now, is that a fair ruling? Honestly, I don't think so. Kasi iba talaga yung causes of action eh. But the way I see it, ang talagang inaddress ng korte rito, yung bang tendency mo na magpa-file ka ng petition, and if it's denied, there is an alternative. Because I think that was the focus of the court. Although as I said nga, if you ask me, medyo mali siya kasi magkaiba naman yung causes of action, iba naman yung psychological incapacity, at saka yung, anong tawag dito, valid marriage license. But nonetheless, it's a draconian measure. Kaya mahirap talaga, no, pag nag-file ka ng nullity, tapos madi-deny, isipin mo forever valid yung marriage ninyo. So, yun lang, dapat makita natin. It's a bit unfair, but what can we do? You know, do the lex sed lex. In fact, may isa pang kaso, yung Kiao. Sa Kiao naman, ang magda dito, yung issue, yung determination ng net profit. Diba, remember sa legal separation, for example, if you're the guilty spouse, you forfeit your share in the net profit in behalf of your common children, or in the absence of the common children, in behalf of the innocent spouse. Ang tanong dito, ano yung net profit? Anong share yung pino-forfeit mo? And this is the case, and this is where the case of Kiao versus Kiao becomes very, very crucial, and to a certain extent even controversial. Kasi yung nangyari dito, they were married in 1977. When they got married, wala silang properties, wala silang exclusive properties. So nagkaroon na lang sila ng pera during the marriage. In fact, ang dami nilang properties. Pag binasa mo yung kaso, 11 or 13 yung properties na napundar nila. May rice field, may corn mill, may rice mill, may factory sila, among others. So, nung naghiwalay sila, nag-file sila nagkaroon ng kaso sa legal separation, the husband was declared guilty. Eto, maganda. Ano yung mawawala sa kanya? Diba? Ano ba yung net profit? Diba, ang understanding natin ng net profit, as of course also as determined by the Supreme Court in that case, the net profit is the difference between the market value of the property during the time of marriage and the market value of the same property
Villasis
at the time of
Law Center.
dissolution. So, yun ang dapat na net profit. Tama po ba? So, halimbawa, may bahay at lupa ka nung kinasal kayo, that's worth 1 million. Now, at the time of the dissolution of the marriage, it's now worth 1.5 million, then the net profit should be 500,000. So, dapat, if you're the guilty spouse, you basically forfeit that, your share in that net profit, na ang definition nga, kagaya nung nabanggit ko. Pero ang problema dito sa Kiao versus Kiao, honestly, hindi gaano malinaw yung pagkasulat dito ng korte eh. Kahit basahin mo ito ng pagbali-baliktad, malilito ka talaga. But long and short of it, ang nangyari dun sa guilty spouse, wala siyang natanggap na kahit ano. And I will explain why. Sa kaso niya halimbawa, di ba, they got married in 1977. Obviously, that was before the enactment of the family code. Ang nangyari sa kanila, ang kanilang property relation would be conjugal partnership of gains. Now, in a conjugal partnership, hindi ba, you have your exclusive properties when you get married. And what happens is that when you get married, you place in a common fund the fruits of your respective exclusive properties. And more importantly, you also place in the common fund all the properties, assets that you will earn during the marriage, either by efforts or chance. Di ba? Malinaw yon. Now, in this case, wala silang exclusive properties. Lahat na earn lang nila during the marriage. Now, as a rule, if you're not the guilty spouse, ang mangyayari lang yan, di ba, during liquidation, i-deduct mo ngayon yung mga debt and obligations. Kung merong legitimes yan, yung presumptive legitimes, di ba, under the family code, i-deliver mo lang din sa mga anak mo, tapos magkakaroon kayo ng tinatawag na net assets, di ba? So, yung net na yon normally, paghahatian nyo lang yon. Why? Because in the conjugal partnership of gains, ang common fund ninyo, yung fruits of your exclusive properties, at saka yung mga naimpundar nyo during the marriage. But in this case, ang definition ng Korte Suprema sa net share, sa net profit, yun mismong na-earn during the marriage. So sabi ng Supreme Court, kung kayo, pareho ka lang, wala kayong exclusive properties, walang ibibigay at ibabalik sa inyo. So ang natira lang dito, yung na-earn nyo during the marriage, and unfortunately, you are the guilty spouse, you will forfeit everything. So which is why at the end of the day, walang nakuha yung husband. Tapos sabi pa ng Supreme Court ngayon, will the condition be different if the property relation is absolute community? Kasi di ba in absolute community, the applicable rule would be Article 102. Because if it's conjugal partnership of gain, Article 129. Ang daming paliwanag ng korte doon, but at the end of the day, wala pa rin siyang nakuha, which if you ask me, doesn't make sense. Pag sinabi nating net profit, dapat it only pertains to profits earned ng properties that supposedly belong to the property regime. So sa tingin ko, ang fair dapat na hatian dyan, halimbawa, yung mga properties, either conjugal or either absolute community, dapat i-determine lang yung market value ng mga properties earned at the time of the dissolution, at the time of the marriage celebration, at saka yung difference nun, yun dapat yung net profit. At yun lang dapat ang ipo-forfeit mo. So technically, kung absolute community yan, lahat ng na-earn nyo, hatiin nyo pa rin magkahati, pero lahat ng tubo at kinita nun, mapupunta dapat doon sa iyong common children or in the absence of the common children, doon dapat sa asawa. Pero sa kaso na ito, hindi ganon. Is it draconian? Yes. Is it unfair? Yes. Pero wala tayong magagawa against said lex. Kaya itong mga kaso na to binabanggit ko para maging mindful tayo na hindi siya talaga ganun kadali. Ang hirap talaga. Wala tayong magagawa. Yun ang naging desisyon ng Korte Suprema. So, ganun talaga, hindi ba? Sabi nga nila, suck it up. Ngayon, pag-usapan naman natin itong issue ng importante din mapag-usapan natin dito, yung issue sa marital obligations, hindi ba? Yung rights obligations between spouses. Di ba sabi ng family code, spouses are expected to love one another, to be loyal to each other, to accord support to each other, etc., etc. But here's one thing you need to understand about this. With the exception of support, tandaan mo to with the exception of support, all other rights and obligations are not really legally demandable. Again, they are not legally demandable. Anong ibig sabihin yan? If your spouse wouldn't shower you with affection, if your spouse wouldn't love you anymore, if your spouse wouldn't be loyal to you, you couldn't actually go to court. You couldn't go to court and compel that person to be loyal to you, to show affection to you, to show you love, to show you fidelity. So, hindi mo siya pilitin. Hindi mo siya pwedeng pilitin. Kasi nga, kinikilala ng batas na ang damdamin, hindi pinipilit. Diba? So, they are not legally demandable. Unlike support, of course, if there is lack of support, you can always ask the court to intervene so that that person who is supposedly obligated to give support can be compelled to give the same. But in the case of, or as regards other rights and obligations, hindi sila legally demandable. That you can as basis for other legal action. Like for example, if you want to file a petition on psychological incapacity, all those failure to call obligations can be used as basis, diba? But for purposes of compelling that person to give you love, to give you affection, hindi yan pwedeng gawin, diba? Sabi ko nga, kahit kailan, ang tatandaan ninyo, hindi pinipilit ang damdamin. So, yun lang yung dapat tatandaan nyo dyan. Now, ano pa bang medyo nalilito tayo na pwede natin pag-usapan? Yung tungkol sa mga bata, hindi ba? Ito medyo magulo ito alam natin yung definition, di ba, ng legitimate children. So, a legitimate child is one who is born or conceived or born inside a valid marriage. So, kaya nga, di ba, if the marriage is voidable, so any person who is born or conceived inside a voidable marriage, the child is always legitimate. Why? Because a voidable marriage presupposes that it is valid until annulled. But if it's a void marriage, except Article 36 and Article 35, Paragraph 5 in relation to Article 53, yung failure of recording, lahat ng bata that are conceived or born inside a void marriage will actually be deemed illegitimate children. But take note of this, as much as possible, the family code favors legitimacy. Sa katunayan, hindi lang family code, kundi the entire legal system aims to favor legitimacy over illegitimacy. Why? Again, because it has to do with the very definition of marriage. Diba? The purpose is to establish conjugal dwelling and family life. And if the children are or spurious, yung pa ginamit na lumang term, ano? If the children are illegitimate, then it is anathema to a very sound conjugal family dwelling that is envisioned by law. Kaya nga, ang nangyayari dito, legitimacy cannot be impugned collaterally. It cannot be attacked collaterally. So if you wish to impugn the legitimate status of a child, it has to be through a direct proceeding. And how do you do that? Well, only the father, I mean not the actual father, but only the husband of the mother can do that. Teka, medyo malabo na, paliwanag lang natin. Kasi di ba remember sa Article 169 and 170, it contemplates a situation where the child is born or conceived inside a valid marriage. However, the father is not really the husband of the wife, but it is someone else. So technically, if you ask me, the child does not actually belong to the husband. Legitimate child siya dapat. But since that child is born or conceived inside that valid marriage, the presumption is that he is legitimate. Now, if you want to impugn said legitimacy, the actual father has no standing to do that. The mother has no standing to do that. The only person who can do that is actually the husband or his heirs in certain prescriptive period, hindi ba? So, ibig sabihin, it should be 1 year from the recording of birth or the knowledge of birth, whichever comes earlier. Or it could, if of course he decides in the same city or municipality, it would be 2 years if he resides in the Philippines, or 3 years if he resides outside the Philippines. So there is a 1 to 3 year prescriptive period within which the husband can impugn the legitimate status of the child. What happens if the husband is not able to do that within the prescriptive period? The answer is simple. The child becomes legitimate for all intents and purposes. Kahit hindi niya talaga ama yung husband. So, kung legitimate siya, pag namatay yung husband, entitled siya to receiving his share as a compulsory heir. Not just an ordinary compulsory heir, but even as a legitimate child. Ang tanong, yung bang totoong tatay, can he now establish paternity? The answer is no. Why? Because according to the Supreme Court, mas maganda na napaboran ang legitimate status because it is in keeping with the preservation of the family. Kasi nga naman, di ba, mas mahirap pag illegitimate children? And that is also the reason given by the Supreme Court why there is distinction between adultery and concubinage. Di ba sa adultery, napaka-simple lamang ng ground. If you have sex with another man, already amounts to adultery. But if you talk about concubinage, it has to be done under scandalous circumstances. Diba? Dapat binahay mo. Diba? Sa adultery, hindi kailangan niya makipag-sex ka lang, pasok na. Why? Because according to the Supreme Court, if we allow adultery to prevail, ang mangyayari niyan, dadami daw yung mga illegitimate children. Pero it doesn't make sense, ano? Diba kung inallow mo yung concubinage, ganun din. Dadami rin naman yung illegitimate children kasi maraming lalaking mag-girlfriend. Mas may posibilidad pa nga dito na magkaroon ng illegitimate children kasi mas seryoso to binabahay mo But nonetheless, that besides the point, ang point ko lang, ang gusto talagang sabihin sa atin ng Korte Suprema, mas pinapaboran natin yung legitimate status. Diba? So again, lilinawin ko lang, you cannot impugn the legitimate status of the child collaterally. So may testate and intestate proceeding uli. Namatay ngayon yung husband. Sasabihin ngayon ng ibang heirs, teka muna, A should not be able to inherit from the father because in reality, he is not his legitimate child because the father is someone else. Now, that particular argument is no longer tenable because once the period has prescribed and the husband is not able to contest or impugn the legitimate status of the child, yun na yun. So, pwede siyang magmana doon talaga sa husband. So, again, at the risk of repeating myself, you cannot impugn the legitimate status of the child. So ngayon, pag-usapan naman po natin yung issue ng custody kasi medyo nakakalito din siya. So yung unang principle na dapat nating tandaan, custody emanates from exercise of parental authority. So ibig sabihin, if you do not exercise parental authority over the child, you also cannot exercise custody over him. Kaya nga kapag ang bata ay illegitimate, ang tatay is deprived of custody. Why? Because under the family code and based on jurisprudence or based on the decisions rendered by the Supreme Court, when the child is illegitimate, only the mother exercises parental authority over him. Kaya yung tatay, hindi ba, hindi niya pwedeng ipagpilitan o ipaglaban na dapat mabigay sa kanya ang kustodiya. So take note of that. However, because he is the father, he can be compelled to give support. And his only right is not really custody, but visitation right. So, pwede siyang humingi like 2 times a week, hindi ba? At kung ilalabas naman niya yung bata, he needs to get the written consent of the mother. Ano ang reason? Kasi nga, kapag ang bata ay legitimate, yung nanay lang ang nag-exercise ng parental authority. But if the child is legitimate, take note of this, both the parents exercise joint parental authority, which means therefore that both of them can also jointly exercise custody over him. Pag nag-away sila, ang rule, if the child is under 7 years of age, mapupunta siya sa nanay. But if he is at least 7 years of age and beyond, meron siyang choice. Pwede siyang mamili. Gusto niya ba sumama sa tatay niya at sa nanay niya. Now, in all these cases, the paramount interest has always been the welfare of the child. Yun ang main consideration lagi ng korte. Kasi ang pinoproteksyonan kung ano ang makakabuti sa bata. Merong isang kaso na maganda yung Relusio versus Masbate. I think it's a 27 or 2018 case. Maganda yung kaso na to kasi si Relusio at si Masbate, they're not actually married. So nagkaanak sila. Ang problema kay Masbate, Renalyn yung pangalan niya, she decided to go to Manila to pursue dentistry. So naiwan ngayon yung bata dito ngayon kay Relusio, di ba? Ang problema, after some time, sinundo nung lolo't lola, yung mga magulang ni Masbate, tapos pagsundo, hindi na binalik. So, deprived of the custody of the child, Relusio decided to file a petition for habeas corpus in order to get back the custody of the child. Ang maganda rito, pinag-usapan maigi ng korte kung ano nga ba yung karapatan niya bilang ama ng isang illegitimate child. And here is where it gets tricky. Di ba kagaya ng sinabi ko, if the child is illegitimate, you do not have parental authority over him. So if you do not have parental authority over him, it therefore follows that you also cannot exercise custody over him. So the question now is, what if the mother is unfit? Because in this case, there's an allegation of abandonment and neglect. Parang sinasabi nung tatay, teka, pinabayaan to ng nanay na pumunta siya sa Maynila eh. So what if the mother is really unfit? Can the father now exercise authority over the child and therefore exercise custody over the child? The answer is still no as a general rule. Because remember, di ba sa 216, again, if the child is illegitimate and the mother is unfit, there are only people enumerated by law who can actually exercise substitute parental authority. Sino to? Yung surviving grandparent. So ito nga in this case, yung lolo't lola, yung mga magulang ng babae ni Renalyn Masbate. Or in the absence of the surviving grandparent, the oldest sister or brother, unless unfit or disqualified. Or in the absence of the oldest brother or sister, the person who actually has actual custody of the child, unless of course declared unfit and disqualified. So if you look at the enumeration under 216, hindi kasama yung tatay ng illegitimate child. So kaya nga, prior to this case, the understanding is that if the mother is unfit, the child does not automatically go to him. It goes to, the custody goes to those people enumerated under 216. Pero ito yung maganda. Sabi ng Supreme Court, if you look at this case, the person who really had actual custody of the child is the father. Except that was actually denied of him when the grandparents decided to get the custody of the child. So, ang sabi ng Supreme Court, even if he is not amongst those enumerated in the law, the Supreme Court understands that ultimately, at the end of the day, the paramount consideration will always be the best interest of the child. Kaya nga sa nangyari dito, ang ruling nila, i-remand sa trial court yung kaso to proceed with trial to determine, number one, if the mother is unfit because there's an allegation of neglect or abandonment, and if it's proven that she's actually unfit, to determine which amongst the people fighting for custody should be entitled thereto, namely the grandparents on the one hand and the father on the other hand. So ang galing, itong kaso na to lumalabas kahit na yung tatay walang parental authority, walang exercise ng custody, pwede niya pa din ipaglaban yung custody ng kanyang anak kahit illegitimate ito, basta patunayan niya lang na unfit yung nanay, and at the end of the day, ultimately, if custody shall be awarded to him, that will be for the best protection and kumbaga upliftment of the welfare and interest of the child. So, ito lang yung medyo magulo sa family code. So, again, hindi naman po to formal review. Nag-usap lang tayo, naguntahan lang tayo. Para lang isip ko lang, ito yung mga bagay na nakakaligtaan. Feeling ko hindi masyadong malinaw kasi napapansin ko sa mga law students, medyo nalilito sila dito. So, clarify lang natin para pag nagbasa na kayo at nag-aral na kayo, nag-review na kayo, things would be a lot easier because you can be guided appropriately, hopefully. So with that, gusto ko lang kayong magpasalamat sa panonood and staying with me until the end of my presentation. And should there be any other question, or do you want to avail of, let's say, learning materials, or do you want to find out how to enroll here at Villasis Law Center, you can always visit the VLC website at www.villasislawcenter or villasislawcenter.com to know more not only about the virtual law companion which we are doing now, but to know other things you want to know about the center. So prepare for the bar examinations at any time, anywhere, and from any mobile device. Together, we can. So maraming salamat sa pagsama sa akin. Itong sa episode na to na tinatawag naming Usapang Misis at Usapang Anak. So wag na yung Usapang Kabit kasi mas alam ni Attorney Villasis yon. So maraming salamat po. Pero joke lang, madam ha. Kilala natin si Attorney Villasis. Napaka-loyal sa'yo. Thank you so much.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
Action by which a party sues another for enforcement or prevention or redress of a wrong. So what are the keywords here? Enforcement, protection of right, prevention, or redress of wrong. Tandaan nyo, enforce, protect, right, prevent, redress, wrong. Okay. Remedy by which a party seeks to establish three things: status, right, particular fact. Okay. Ano yung sa television, yung commercial? SP. Suggested retail price. So, tandaan nyo, to establish S
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish to the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule? under Rule 6 that together with the pleading initiatory pleading, which is made as an integral part thereof,
What is our definition of the practice of law? We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making venture. And law advocacy is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers, and gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is
In Spouses Minjola British Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are 2 aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act in violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.